My lady, my lords, I concluded just before the break by referring to the Advocate General Bobek's opinion in Cabeg. Now, and you may remember he said that for a matter to relate to a contract, it should be title-based. Sorry, an insurance relationship should be title-based. And he explains this further in a decision called Flight Right against Air Nostrum, which is at OA3, tab 63, page 1708. And this was a case concerning a claim brought by passengers against an operating airline, and interposed between them was a contracting airline. And the question arose whether this was a matter relating to a contract. And the Advocate General at page 1720 said in paragraph 54, thus, in my understanding, the jurisdictional rule in Article 5.1, now 7.1, of the regulation, and in Article 7.1 of the regulation recast, is based on the cause of action, not the identity of the parties. What matters is whether the underlying original source of the rights and obligations which are being disputed and the reason that claim is being brought against the specific defendant follow from a contract. If they do, the ensuing action aiming at their enforcement is a matter relating to a contract, even if, as is often the case with legal provisions protecting consumers, the rights and obligations that are being correctly enforced in the individual case had been inscribed, namely rendered applicable without the possibility of derogation into the contract by the operation of mandatory statutory rules. In the next paragraph, there are two systemic analogies within regulations number 44 and the recast regulation that confirm that point. First, similarly to the interpretation of a notion of a matter relating to insurance, what is relevant is that the respective applicant is enforcing rights that originate from an insurance contract and not whether he or she was a party to that contract. Further, see my opinion in Cabeg at paragraphs 36 and 37. Now, just pausing there, so what the Advocate General is doing is clearly drawing an analogy between the phrase matters relating to a contract in Article 7 and matters relating to insurance in Section 3. And of course, the focus of the Advocate General's opinion is whether a passenger or an airline can enforce contractual rights against a person, the operating airline, with whom they had no contract. And so it's basically like an assignment. And he goes on. Second, one can equally refer to the cases of legal succession in the third party's claim. Under specific circumstances, a third party may step into the shoes of another in order to enforce claims that arose in a legal relationship to which the claimant was not party. Again, a third party enforcing rights from the original contract may be entitled to do so under the head of jurisdiction of a matter relating to a contract, even if it itself was not a party to the original contract. And going on to the next page, as the European Commission notes in Frahoy, the court did not, in principle, exclude that matters related to contract could cover a situation in which a third entity sued one of the parties to a contract based on a statutory assignment of a claim to a third-party claimant, if the consent of the defendant to the relevant obligation could be established. That shows again that for a matter to fall under the head of jurisdiction, pursuant to Article 5.1 or 7.1, the claim does not necessarily have to be between the original parties to the contract. This is the case provided that there is a contractual basis under which a third-party claim may be held liable for the discharge of obligations that were subscribed to contractually by or in favour of that person, that third person. So what the Advocate General was basically saying in both Cabeg and in this decision was that for a matter to be a matter relating to a contract or insurance, what has to be enforced are the rights and obligations arising in the particular insurance contract or contract. And if we go to see what the court said in this case, at this is page 1738, at paragraph 56, the court raises the general question as whether it's a matter relating to a contract. And I think we can therefore, in paragraph 57, as a preliminary remark, it is necessary to point out that although the referring court does not raise any issues in that regard, the answer to the first question is relevant also to another case, insofar as it follows from the order of the reference in that case that in the circumstances of this case, the operating air carrier is not the contracting partner of the passengers concerned either. Then if we go to 58, it is apparent from the court's case law that the concept of matters relating to a contract must be interpreted independently in order to ensure that it is applied uniformly in all the member states. In that regard, the court has also held that in the case where non-performance of a contract is relied upon to support a claimant's action, all obligations arising under the contract must be considered to come within the concept of matters relating to a contract. The court has also stated that even if the application of the rule of special jurisdiction for matters relating to a contract does not require the conclusion of a contract between two persons, it nevertheless presupposes the existence of a legal obligation freely consented to by one person in respect of another, and on which the claimant's action is based. Paragraph 61 on the next page, 1739, it follows, as Advocate General Bobeck stated in paragraph 54 of his opinion, that's the paragraph we've just referred to, that the rule of special jurisdiction in matters relating to contract provided for in Article 5.1 and 7.1 is based on the cause of action, not the identity of the parties. In paragraph 62, in that regard, the second sentence of Article 3.5 states that where an this is another regulation altogether, states that where an operating air carrier which has no contract with the passenger performs obligations under this regulation, it is to be regarded as doing so on behalf of the person having a contract with that passenger. Therefore, that carrier must be regarded as fulfilling the freely consented obligations vis-à-vis the contracting partner of the passengers concerned. Those obligations arise under the contract for carriage by air. So, and then concludes in paragraph 64. So, in this particular case, the court, adopting what Advocate General Bobeck says, is that the claim, even if it's a claim of an assignee, must relate to a cause of action arising for breach of the rights and obligations of the contract in question. And if we transpose that over to the notion of matters relating to insurance, again, which is the analogy drawn by the Advocate General, then it must mean that the claim against the bank, for it to be a matter relating to insurance, must be for breaches of the rights and obligations in the insurance contract, the policy, and not something else. Now, my lady, my lords, this notion of the material nexus test, which has been adopted by the Court of Appeal, it was adopted in three cases. My learned friend referred the court to the decision in Alpha Laval, that was a decision of Lord Justice Longmore, decision of Bosworth and Arcadia, which is a decision of the Court of Appeal, I think Lord Justice Gross, and another case called Merenson and UKOS. Now, all of those cases apply Alpha Laval. Obviously, the first one is Alpha Laval. And I'm happy to return to the judgment, but what Lord Justice Longmore was doing was just looking at the words matters relating to insurance and defining that phrase without any other assistance. It was just looking at it as a linguistic exercise. And of course, that decision predated the Brog-Sitter decision. So Lord Justice Longmore was not in a position to apply Brog-Sitter to that particular case. By contrast, in Bosworth and Arcadia, that was a decision where Lord Justice Gross did consider the Brog-Sitter decision, but also the Alpha Laval decision, and came up with a material nexus test. But I'll take you to it, because my learned friend did refer to it, which is OA1, tab 43, page 1271. and it's paragraph 63. And before I refer to what Lord Justice Gross says, it is worth remembering that what the issue in question here was whether or not there was a matter relating to a contract of employment. So the same phrase, albeit not under Article 7.1, but under Section 5 of the regulation. And what Lord Justice Gross says at paragraph 63, subparagraphs 1 and 2, is that plainly we are bound by previous Court of Appeal authority, and Lord Justice Gross refers to Alpha Laval specifically. Likewise, the decisions of the ECJ and Brogsitter and Holterman are binding. In my judgment, there is no conflict between the English authorities and the ECJ decisions. And then a submission is made to him by Mr. Foxton that it's a question of how you plead, whether the matter could be pleaded as a breach of the relevant contract. And I would like to take it up at page 1273. This is paragraph 66. It's about halfway down the first paragraph on the page, and it's where it begins accordingly. Accordingly, it does not suffice to pose the literal question as to whether the conduct complained of may be considered a breach of contract. Now, pausing there, I would say that's directly contrary to what Brogsitter says. Instead, because that's what that is, and it's actually a quote from Brogsitter. Instead, the requirement that the legal basis of the claim can reasonably be regarded as a breach of contract assists in directing the focus of the inquiry to the substance of the matter, with the result that it's indispensable to consider the contract in order to resolve the matter in dispute. Now, and this is a test and an approach indistinguishable to my mind from that adopted in Alpha Laval, that there be a material nexus. Now, where I suggest Lord Justice Ross, maybe with respect to him, may have been on the wrong path, is by in some way downgrading the Brogsitter test to a test of indispensability, which we saw from Brogsitter itself is not the test. And he goes on in paragraph 67, interestingly, by saying, I turn to apply these conclusions of law to the facts of the appeal. As a matter of reality and substance, do the conspiracy claims relate to the appellant's individual contracts of employment? Is there a material nexus between the conduct complained of and those contracts? Then he goes on to say, can the legal basis of these claims reasonably be regarded as a breach of those contracts so that it's indispensable to consider them in order to resolve the matter in dispute? That's the way he puts it. Now, insofar as he's saying that material nexus on its own or indispensability on its own is sufficient, I would submit he's wrong, because it's contrary to what Brogsitter says. Now, my learned friend also referred to a decision of the Court of Appeal, I think it was Court of Appeal, in, let's check that. Yes, in Merenson, and we refer to this in our written case, but the point there, of course, is that that was a material nexus test, but there was it was clear from the judgment there was no dispute between the parties as to the test. So it wasn't really a point which was argued before the Court of Appeal. Now, by contrast with those decisions of the Court of Appeal, there is another decision of the Court of Appeal which the Court should have regard to, and that's the decision in commentary, which is at OA1, tab 45, page 1318. And this was a claim by an employee against a travel company, and that travel company had contracted with the employer of the employee. And the issue in this particular case was whether it was a matter of relating to a contract. And I think we can pick it up at yes, the travel companies, there's a statute which imposes a strict liability test for proper performance on the contract of itself. And after referring to the various authorities, Lord Justice Coulson summarize the position. This is at page 1336. As follows. Applying Brogsitter, Ergo, and Amazon, the contract between BMP and the respondent was not simply part of the background to the claim, as was found to be in Bosworth. It is the basis for the obligations of which the respondent is said to be in breach. Now, supposing that is the Brogsitter test. Although it is unwise to be over-definitive as to the precise test to be derived from the European authorities, I derive the following from these three cases, and it's little a which is most pertinent. The mere fact that a contracting party brings a civil liability claim against the other party does not by itself mean that the claim concerns matters relating to a contract, but it will be sufficient if the conduct complained of may be considered a breach of contract, or if the purpose of the claim is to seek damages, the legal basis for which can reasonably be regarded as a breach of the rights and obligations set out in the contract. So here is a case where the Court of Appeal did apply the Brogsitter test. And at paragraph 53 on the next page, page 1337, on an application of all and any of those principles, it's clear that the pleader's strict liability claim can only be characterized as a contractual claim. It's a claim for damages for breach of the obligations set out in the contract freely entered into by both sides. That contract is the source of the relevant obligations and imposed the necessary commitments. And to put it another way, to use Judge Waxman's words in AXA, the contract was not a stepping stone to the ultimate liability of the respondent, but the basis for the obligation actually relied upon. So even though there may be an insurance contract which is a stepping stone to the cause of action, unless the claim is a claim which may be regarded as a breach of the rights and obligations of the insurance contract, that won't be a matter relating to insurance.
Suppose an employer overpays by mistake the employee. How does that fit within the Brussels recast regulation?
So if it's a claim under the contract, for example, it's a claim for restitution.
Yes.
Well, unless it could be, the way the court deals with it is a claim for a matter which may be regarded as a breach of the rights and obligations under the contract. And so probably the best, in those circumstances, it might be contractual, it might not, depends on how it could be regarded by the European Court. Now, in this respect, it's probably worth recalling that in a case called Agnew, and this is an answer to your question, my lord, I hope I'm not ignoring it. There's a case called Agnew, which my learned friend, I think, showed you in another context earlier. And it's at OA1, tab 40, page 1203. This was a case where there was an insurance contract, and the issue wasn't. And the issue was whether it was a matter relating to a contract or a matter relating to tort, and there was also an issue as to whether it was a matter relating to insurance. But there was an insurance contract which had been induced by the making of a misrepresentation, and the House of Lords held that the claim for restitution, for the avoidance of the contract, the setting aside of the contract, was a claim relating to a contract, but also said that, and there was only one law lord who said this, was Lord Hope. He said, and he was the only law lord to consider it, insofar as there would be a claim for damages for misrepresentation leading to the contract, that is not a matter relating to a contract. It's a matter in tort. So to answer my lord's question, if it's a claim for restitution of funds, it may well depend on whether there's an implied term as to repayment in the case of overpayment, which would clearly be a matter relating to a contract. If it's a claim for a claim in restitution as a matter of law, unjust enrichment, then it depends on whether it could be regarded as a breach of the contract, and it depends on the circumstances of the case, it seems to me.
Because, I would have thought that having regard to the object which is served by Section 5, that even if the claim for restitution in the case I've put to you is in law, so not by virtue of any contractual term, that the object of protection of the employee in Section 5 would, well, I would be inclined to say, clearly cover the case of the claim for restitution by the employer. You seem to be saying not.
Well, no, I'm saying it might. Certainly if it's pursuant to an implied term of the contract, it would.
Right, but I'm asking you...
But you're saying if it's an extra contractual claim, if it's an extra contractual claim for restitution, then it's a question, the question to be asked is, may it reasonably be regarded as a breach of the rights and obligations in the contract? That's the test with Brogsitter. May it reasonably be regarded. But if we come back to Agnew, though, what's intriguing is, in line with the European authorities, if the object of the claim is avoidance or annulment of the contract, that's treated as a matter relating to a contract, even though you're not asserting the existence of contract, you're asserting the opposite. But if you're claiming damages for misrepresentation leading to the contract, that is not a matter relating to a contract, according to Lord Hope. It's a matter relating to tort. So if you take this case, there's a claim for damages for misrepresentation, which led to payment under the pursuant to the settlement agreement, then assuming the settlement agreement was some way a matter relating to a contract, that itself would not be, following this approach, would not be a matter relating to a contract, it would be a matter relating to tort. And just for your reference, it's page 259, sorry, it's page 1210 of this Agnew judgment. So my lord, I hope I've...
Yes, thank you very much.
My learned friend referred to the House of Lords decision in Jordan and Baltic. The court may recall that that was a case where there was a fraudulent claim under an insurance policy, and the insurer's counterclaim for a fraudulent conspiracy against both the insured but also the directors behind the insured, or of the insured. And the House of Lords held that that was a matter relating to insurance. I have 2 points to make about that. The first is that it's distinguishable in our case because here we've got a settlement agreement which is interposed, and it's well known that a settlement agreement is not a contract of insurance, even if it's settling an insurance claim, and therefore doesn't attract the duties of good faith and the like. The second point is that the Court of Appeal below considered Jordan and Baltic, together with another case which my clients relied on, which was a decision of the court in the Icarian Reefer. And I'll give you a reference, no need to turn it up. It's PA1 tab 9, and it's page 718. And in that particular case, it was a claim for, the main proceedings were concerned a claim for an indemnity under a marine insurance policy. And it was, it was an allegation of willful misconduct. But there were also ancillary proceedings for costs to be paid by third parties. And the court in that case held that it wasn't a matter relating to insurance, even though it was an ancillary proceeding to the main proceeding. Now, the Court of Appeal, if we could turn to CV2, tab 7B, page 299.
Sorry, what was the page reference again?
299.
299.
299.
Thank you.
The Court of Appeal referred to both the Icarian Reefer and also Jordan Grand Prix against Baltic, and said at subparagraph 4 at the top of the page, the three English authorities to which the judge referred, as Mr. Justice Tier referred, do not furnish any significant assistance. Both the Icarian Reefer and Keith concern factual situations very far removed from the present case. Jordan Grand Prix was much closer, the decision was that the avoidance of an insurance contract on the ground of fraud was held to be a matter relating to insurance. But no settlement agreement had been interposed, so no issue arose in that regard, rendering that authority instantly distinguishable from this case. And my submission had been it was distinguishable, and you can see in the next sentence that the judge then, having broadly accepted the 4 points referred to in the preceding paragraph, then said, wrongly I say, he parted company with my submissions. So those earlier decisions of the English courts in Jordan Baltic, and I would have to accept Icarian Reefer, don't really take the matter further forward, not least because they predate the Brog-Sitter test. Now, in this particular case, at paragraph 78 of the Court of Appeal judgment, which is page 301, the court came to the conclusion that the question whether the vessel was lost by reason of a peril insured against or by willful misconduct is a crucial question in the action. And of course I accept that it's certainly an important question, but that's not the question which the court has to ask in order to determine whether it's a matter relating to insurance. The question is whether the claim against the bank can be reasonably regarded as a claim for a breach of the obligations or rights under an insurance contract. The bank says it's not a party to the insurance contract. Indeed, it's a loss payee and an assignee. And whilst the issue of willful misconduct is relevant to the issue of misrepresentation and mistake, it doesn't mean that the claim is a matter relating to insurance for the reasons I've given. And indeed, if one considers the Agnew decision, in that particular case, Lord Hope said that a claim for damages for misrepresentation inducing the insurance contract is not a matter relating to the contract. It's a matter relating to in tort. So for those reasons, I would submit that this claim is not a matter relating to insurance, and therefore the insurance section does not apply. And indeed, for reasons which were touched upon during oral argument yesterday, certainly this is a claim which is remote or more remote from the insurance contract than the phrase matters relating to insurance allows. Now, of course, if I'm wrong about this, issue number 2, we move on to issue number 3, which is the weaker party principle. And in this context, the Court of Appeal was, we say, rightly held that the bank did not require the social protection extended by the insurance section because it was not within a class of persons who were economically weaker. And for this purpose, the 3 questions for the court to consider are first, is there a relevant exception to the application of the insurance section, and in particular Article 14, in respect of economically weaker parties, or non-economically weaker parties? Secondly, if so, how does one identify the classes of persons which fall within that exception? And third, does the bank fall within that class? Now, my learned friend, and indeed I, referred the court to recital 18 of the regulation, which identifies the rationale of the insurance section as well as sections 4 and 5, which is the protection of economically weaker parties. And in essence, the court, my learned friend, before I take you to the authorities, my learned friend has 2 points of principle which he raises against me. The first is that Article 14 should be regarded as a mandatory rule and should not attract the exception. And the second point is that there are 4 parties who are deemed, and by deemed he construes that to mean irrebuttably presumed, to be economically weaker parties who require the protection of the section. and they are the policyholder, the insured, the beneficiary, and an injured party. Now, just on the first of those points, this is whether it's Article 14 creates an unqualified rule that the insurer must sue the beneficiary only in the defendant's domicile. Now, my learned friend accepts, of course, that's still subject to Articles 15 and 16, which provide an exception in relation to contrary jurisdiction agreements. But insofar as there is a weaker party exception, there is no reason why it should apply to some of the provisions in the insurance section, but not others. Article 14 does say that the insurer may only sue in a particular identified jurisdiction. However, it uses the word only to distinguish it from the permissive jurisdictions referred to in the preceding articles. But if there is an exception based on the economically weaker party, my lady and my lords, there is no reason why it should apply depending upon whether it's the insurer suing or the insurer being sued. Because the whole purpose of the section is to provide social protection to economically weaker parties, and that doesn't alter as to whether it's an Article 11 case or Article 13 case or an Article 14 case. Now, dealing with the second point of principle, firstly, even though the policyholder, the insured, the beneficiary, and the injured party are identified as within the insurance section as such, and they may be deemed to be economically weaker parties, I would submit that doesn't mean irrebuttably presumed to be economically weaker parties. There may be a case where they're not. And to make that good, if the purpose and the rationale of the insurance section is to provide protection for weaker parties, and that rationale is not needed or fulfilled by the facts at hand, there is no need to then apply the insurance section. It's just unnecessary. And that is the reason why, in the cases dealing with reinsurance, I'd ask the court to bear in mind that a contract of reinsurance is a contract of insurance. And a reinsured under a reinsurance contract is essentially an insured under that contract or a policyholder. Now, if the court has held that the insurance section doesn't apply to contracts of reinsurance because insurance professionals do not fall within the class of persons who require that social protection. Now, that must mean, therefore, that just because a reinsured is an insured under a reinsurance contract, that they're irrebuttably presumed to be an economically weaker party. Because if they were, then the insurance section would have to apply even to reinsurance contracts. The other point to bear in mind on this second point of principle is my learned friend regularly referred to the bank as the beneficiary. Now, it is identified as a loss payee in the policy, but it's also an assignee. And all of the authorities which we've been considering, and which I will take you, my learned friend took you to, which deal many of the authorities which deal with this issue, deal with issues of assignment, whether it be statutory assignment or contractual assignment. But it's assignment. Sometimes it's referred to as subrogation, but it's still a statutory assignment or a contractual assignment. And that's exactly what the bank is in this particular case. It is an assignee of rights under the policy.
Yes. But those cases are about assignations or assignments or subrogation after the casualty has occurred.
I don't think that would make a material difference.
But the assignment of the benefit of the of a policy in advance of a casualty renders the assignee a beneficiary of a policy.
Well, it's a beneficiary in the sense of, if a beneficiary has a particular meaning in this context. A beneficiary means someone who's identified to be entitled to payment of insurance proceeds in an insurance contract. An assignee is not a beneficiary in that sense.
But in this case, the bank is a beneficiary.
But also an assignee.
Yes, but it is a beneficiary.
And
yes,
I accept that, my lord. And I'm not going to
and the cases, I think Lord Reed's right. The cases concern assignees after the insured peril has occurred.
But I would say there's no material difference. But the fact that someone's an assignee means that they're not a party to the original contract. And therefore, they are a third party seeking to enjoy the rights of a contracting party. And that's exactly what the assignees in the particular cases are concerned with, even though the assignments take place after the relevant accident or loss.
But it's when the peril occurs that the right to the benefit under the policy vests. So
yes, I agree with that, my lord. Yes.
So one is, well, that may be a material difference.
No, my lord is right in the sense that if you have an assignment before the loss, which gives rise to a claim under a contract of indemnity, such as an insurance contract, then the assignment, if you like, to use a vulgar phrase, kicks in at the time of the loss. I accept that. But as a matter of the relationship of the assignee to the contract and the contracting parties, it's no different whether it's assignment before or after the loss. That's my submission. And I say that insofar as the weaker party principle is applicable, we say, for the reasons given in relation to reinsurance cases, it applies to a beneficiary because a reinsured in that particular case is an insured or a beneficiary under the reinsurance contract. And therefore, it can't be irrebuttably presumed to be a weaker party. It must be rebuttably presumed. And secondly, insofar as they're an assignee, they're not one of the four types of individual referred to in the insurance section.
I was just puzzled by that. Why isn't an assignee a beneficiary? I mean, is there a definition? Because I'd have thought beneficiary is an autonomous term. So not depending upon the intricacies of the national laws.
I'm not aware of a definition of beneficiary in the context of the insurance section.
Right.
I will think about it. I'll ask my learned junior to look at it.
So if I'm standing back and looking at it through the eyes of the language used by the drafter of the regulation, I would have thought one might well describe the assignee of a policy as a beneficiary.
Well, all I would say is, in the insurance context, it would be an unusual designation. When you speak of an assignee, you don't normally speak of a beneficiary. If I have a life insurance policy, for example, the life insurance policy may be assigned to my bank as security for the loan, and the bank will be an assignee, but the life insurance policy will also include myself as a life insured, but my dependents, for example, as beneficiaries. They're the persons entitled to payment in the event of an insured event. So as a matter of ordinary jargon, if you like, you wouldn't normally identify the beneficiary or equate the beneficiary with an assignee or vice versa. But what is clear, that it seems to me that if you're an assignee, the weaker party principle, which is referred to in the authorities, has been applied to assignees. And I take my Lord's point about the difference between whether it's an assignment before and after the loss. But the fact is that this principle has been applied to assignees. My learned friend went through a number of the relevant authorities, such as Gerling, UGIC, Pellew, and GIE against Zurich. And I don't think I need to refer to those again. My learned friend also referred to the decision of the Court of Appeal in New Hampshire against Strabag, which was at PA1, tab 10, page 727. Actually, if you could pick it up at 725. I mean, the important point to bear in mind here, of course, is that this was a decision of the Court of Appeal in 1991. And so it was before the string of authorities of the European Court which I rely upon to establish this exception. And what Lord Justice Lloyd says at page 725 of the bundle, in the first column, he begins by referring to section 3, and he says it's essentially protective in nature. It was intended to protect a small policyholder against a more powerful insurer. This was achieved inter alia by Articles 8.2, which provides that a policyholder can sue the insurer in the courts of its own domicile, irrespective of the domicile of the insurer, and by Article 11, which requires that proceedings brought by the insurer shall be brought only in those courts. And it's absolutely right that the argument was that given that there was and this is page 727 now, it was submitted by Mr. Pickering, this is the first column, that if reinsurance is excluded, it can only be on the basis that insurers and reinsurers are normally of equal bargaining power. If that is indeed the reason, then the same reason should apply as between other parties of equal bargaining power. Now, just pausing there, that is the basis upon which the European Court has treated reinsurance contracts as not falling within the insurance contract. But then Lord Justice Lloyd then states, I'm not persuaded the exclusion of reinsurance may not be justified on a narrower basis, that both insurers and reinsurers are in the same business of taking risk for a premium. Contracts of reinsurance may take many forms, but in the case of treaty reinsurance, at any rate, one does not normally think of the reinsured as a policyholder. Putting that on one side, I do not think it would be right to assume before the European Court has pronounced that reinsurance is not covered by Section 3. In any event, it would not be right to assume that Professor Schlosser's views depends on insurers and reinsurers being of equal bargaining power. I regard the arguments based on the exclusion of reinsurers as of limited assistance to the plaintiffs. And then Lord Justice Lloyd then makes his conclusion in the next paragraph. So this decision actually offers very limited assistance, I would suggest, because the issue hadn't yet been dealt with by the European Court. The European Court did consider it by reference to the rationale of the issue of reinsurance, that is, by reference to the rationale, which is the notion of protection for economically weaker parties. And that's in accordance with the decision of Lord Justice Gross below, when this is CV2, tab 7b, page 309, when he addresses this, the argument based on this authority. Secondly, and with respect, this is paragraph 110, with respect to Mr. Berry's argument to the contrary, I'm not persuaded that we are bound by New Hampshire to decide the present issue in his favour. The submissions advanced and rejected in New Hampshire were of a very limited nature. New Hampshire does, of course, serve as a powerfully persuasive reminder that it is not open to rerun the UK's unsuccessful accession negotiations. Thus, as explained in Pellew, the mere size and international stature of, for example, the policyholder would not preclude the operation of the Section 3 regime. And then in paragraph 111, Mr. Lord Justice Gross then addresses Mr. Berry's argument about the Article 14 giving rise to an irrebuttable presumption that the party in question is the weaker party for the purposes of that argument. Now, that's the issue of the exception. The question is, if there is an exception, what classes of persons fall within it? And the exception is established by the decisions which we've referred to, but also by the decisions which my learned friend also referred to by reference to my written case. And I'll try to limit reference to these decisions as much as I can. The first one was Vorarlberger, and that was a case where a German domiciled driver collided with the back of another car, causing injury to the driver of the car in front. And that driver was domiciled in Austria. The injured party claimed benefits from the Austrian Social Security Institution who sought an indemnity from the former driver's liability insurers, and the claimant commenced proceedings in Austria against the insurers. And the court held that even though the injured party was an economically weaker party, the person who succeeded to those rights to claim against the insurers, which was the Austrian Social Security Institution, was not an economically weaker party, and therefore the insurance section didn't apply to that party. And it's worth bearing in mind that the Social Security Institution in that case was not an insurance professional. And then we can come back to CABEG, which is PA2 tab 26. And this was a case where, so it's page 929. This is a case where CABEG was a public law establishment in Austria, and they paid the salary of an injured employee. That employee was injured by a driver who was insured by a French insurer. And CABEG, to whom the employee's financial entitlement passed, continued the suit against the French insurer in Austria. And at page 940, my learned friend referred the court to the Advocate General's opinion at paragraph 47, which says it's also to be kept in mind that in contrast to the matters relating to employees and consumers, the notion of the weaker party in insurance-related matters is defined rather broadly. Now, I'll just ask you to mentally note that that's the first sentence, and then it goes on. It includes 4 categories of persons: the policy holder, the insured, the beneficiary, and the insured party. As a matter of fact, these parties may be economically and legally rather strong entities. That flows from the broad language of the insurance-related provisions of Regulation 44, as well as from the types of insurance described therein. And then I think my learned friend then referred to page 941, paragraph 61 to 68. And I think I can pick it up at page 60, paragraph 67 on page 942. I would thus suggest that the subrogation to the rights of the directly injured party triggers the passing on of the forum actoris to any subrogee, including both physical and legal persons. And then unless, one, that subrogee is herself a professional in the insurance sector, to whom the claim passed on the basis of an insurance relationship she formed with the directly injured party, brought about either by operation of law or on the basis of an insurance contract. Or two, a subrogee is an entity regularly involved in the commercial or otherwise professional settlement of insurance-related claims, who voluntarily assumed the realization of the claim as part of its commercial or otherwise professional activity. Now, this is, those are the classes, and remember the issue I'm addressing at the moment is what classes of persons fall within the exception, if the exception does exist. So the two exceptions identified, or classes of persons identified by the Advocate General, are an insurance professional or someone who's regularly involved in the commercial or otherwise professional settlement of insurance-related claims.
And what he's talking about, I think, as he makes clear in the first line of paragraph 67, is he's dealing with the rights of the directly injured person. So those are the rights under what's now Article 13.2.
Yes, but an injured person is a party, is one of the persons identified in the insurance section.
Yes, I appreciate that. I mean, it strikes me that this case and Hopso and Vorarlberger, and maybe the others, are all concerned with the rights given to an injured person under what's now Article 13.2, and that's why there is an extension involved in the argument that those rights should be accorded to persons who weren't actually injured but are the assignee or the beneficiary of a subrogation by the injured person.
Well, if the rationale of the entire insurance section is the social protection of economically weaker parties, then if the extension of the protection may be offered to assignees, there's no real reason, I would say, as a matter of principle, why the protection should be limited to, or the non-protection if they're not economically weaker parties, to assignees of injured parties as opposed to assignees of policyholders, insureds, or beneficiaries. And it's very hard to articulate why should be a distinction in that respect. My Lord. Now, if we go to the decision of the court, which is at page 951, paragraph 28, the court says, in the same way as matters relating to workers and consumers, and as is clear from recital 13 of the then regulation, a matter relating to insurance is characterized by a certain imbalance between the parties, see GIE against Zurich, that the provisions of that section aim to correct by enabling the weaker party to benefit from rules of jurisdiction more favorable to his interests than the general rules provide for. See Vorarlberger. The questions of the referring court is the classification of employer, which is a statutory assignee, so of the injured party's rights as the weaker party, arise from the finding made by the court that a social security institution, which is the statutory assignee of the rights of the person directly injured in a car accident, cannot be classified as such, whereas a person to whom the rights of the person directly injured have passed, such as an heir, or such as an heir may be. And then at paragraph 32, which I think my learned friend referred to, it says, as the Advocate General observed in AG 47 of his opinion, the notion of the weaker party has a wider acceptance in matters relating to insurance than those relating to consumer contracts or individual employment contracts. And it's unclear to what extent that paragraph's being adopted, paragraph 47 that is, being adopted by the court, because it's essentially adopting the first sentence of the paragraph rather than the entire paragraph, if that's a point of distinction. But if we go on to the next page at 952, Further, as the referring court observed in its order for a reference, a case-by-case assessment of the question whether an employer which continues to pay the salary may be regarded as the economically weaker party in order to be covered by the definition of injured party within the meaning of Article 11.2 would give rise to the risk of legal uncertainty and would be contrary to the objective of that regulation laid down in Recital 11 thereof, according to which the rules of jurisdiction must be highly predictable. Therefore, it must be held that pursuant to Article 11.2, employers to which the rights of their employees to compensation have passed may, as persons which have suffered damage in whatever their size and legal form, rely on the rules of special jurisdiction laid down in Articles 8 to 10 of that regulation. Thus, the employer to which the rights of its employees have passed in order to be reimbursed for the salary paid to the latter during a period of incapacity to work, which solely in that capacity has brought an action for damages, may be regarded as weaker than the insurer that it sues, and therefore is able to benefit from the possibility to bring that action before the courts. It follows that an employer to which the rights of an employee injured in a road accident have passed and for whom it continued to pay his salary may, as the injured party, sue the insurer involved in that accident before the courts of the member state in which the employer is established, where a direct action is permitted. So what the court is doing here is basically identifying the fact that a assignee, whether an injured party, and I would go so far as to say any other party to an insurance contract, is entitled to the same social protection offered by the insurance section, provided that the rationale is met, provided that that assignee is an economically weaker party. However, the court says, but what is undesirable, having regard to the notions of predictability and certainty, is that you undertake a case-by-case assessment in every case. So what the Advocate General proposes is identifying a class of persons who would benefit, who would be treated as a non-economically weaker party and therefore not entitled to the benefit of the insurance section. And what, of course, the Advocate General did in this particular case was identify the insurance professionals and persons who are commercially involved in making insurance claims.
But size and legal form is irrelevant, apparently.
Well, so it's class which matters. So if you fall outside the class, my lord, it doesn't matter if you're a large organisation or not.
But why? What's the rationale of the class test?
To avoid a case-by-case assessment, an individual. That's the rationale of the court. Now, I don't particularly like it, but that's what the court has said. And at first instance, when we had the decision of the European Court in Vorarlberger, we made submission on the basis that you could undertake that individual case-by-case assessment. But this decision of Cabeg was delivered in the same month as the decision of Mr. Justice Tier, and it wasn't available to the parties at that hearing. But once this decision was made, before the Court of Appeal, certainly my clients adopted, and I think my own friends' clients indicated that a case-by-case assessment was no longer permitted.
It seems very remote from the protection of the economically weaker. So Unilever, as an employer, could get the benefit if it was subjugated to the injured party's rights, while a small insurance broker might not.
And that's particularly the case with Mr. Hofso, which is a decision I'm going to come on to.
Yes.
Because Mr. Hofso was regarded by the court as falling within that special class. It was a man of smaller means compared to very large claims companies. And that argument was put and dealt with by the court.
Well, it's very hard to find any principle behind this approach.
Well, there are two principles at play here, my lord, if I may suggest. The first principle is that the insurance section needs to be applied so as to give the social protection it provides to those who require it, because they're economically weaker. However, in tension with that is this notion of predictability and certainty. And unless you identify classes of persons and you adopt a case-by-case assessment, and all I'm doing is repeating the court's rationale, then the intention with that is that predictability notion. Therefore, the solution which the court has come to is this notion of identifying a class. Now, the effect of it is as follows. my lady and my lords, is that if you're outside the class, it doesn't matter what size you are. You could be a very powerful economic being, but you're entitled to rely on the insurance section. If, however, you're inside the class, it doesn't matter if you're not a powerful economic being, you're within the class, and therefore you're not entitled to the insurance section. And I think that's the unavoidable consequence of this treatment of the exception by the European Court.
I mean, this particular judgment and that passage,
Yes.
paragraphs 34 to 36, almost looks to me like Mr. Berry's deeming point. What the court seems to be doing is saying Article 13.2 applies back, by reference back to Article 11.1b, where you have people grouped together. Mr. Berry's point focuses specifically on Article 11.1b, that if you're within one of those identified persons, policyholder, insured, or a beneficiary, you're deemed to be the weaker party. And in Cabeg, as best I can follow it at the moment, the court seems to be looking at Article 13.2, noting that it refers back to Article 11.1b and that group of people who are deemed to be weaker, whether in fact they are or not. And saying, if you're the employer who has paid one of those groups of people, whether economically weaker or not, you too, this is paragraph 36, may be regarded as weaker than the insurer.
Yes. So, but unless you fall, so if you it's all tied up in HOFSO, which I'm going to come to, my lord. But looking at Cabeg, you've got the Advocate General advocating that there are special classes of persons who are not entitled to the protection offered by the insurance section. And then you've got the court saying, in this particular case, firstly saying case-by-case assessments are not desirable, but secondly saying if you have an employer who's inheriting the rights of the employee in this particular circumstance, unless they fall within one of those classes, they're entitled to the benefit of the insurance section.
But why isn't this an authority against you and supportive of Mr. Berry's deeming approach?
Because all it really depends upon whether or not there is the persons involved in this particular instance fall within the class. So if in this particular they didn't, that was the focus, I suggest, of the court's decision. Now, if Mr. Berry was right on the deeming principle, that wouldn't explain why reinsurance has been held by the court to fall outside the scope of the insurance section. So, if I may come on to so the other thing to note about Cabeg is that it was a public law establishment which was concerned in that particular case, and therefore not one of the persons falling in the particular class. But if we come on to HOFSO, which is at PA2 tab 25. Sorry, just forgive me for one moment. beg your pardon. So Hofso, it's PA2 tab 25. And in this particular case, a vehicle had been damaged. Sorry, it's page 918 is the first page of the report. A vehicle damaged in a traffic accident in Germany was caused by a German driver who had a German insurance policy issued by a German insurer. The owner of the vehicle assigned the claim to Mr. Hofso, who exercised commercial activity in Poland. Mr. Hofso sued the insurer, the German insurer in Poland, and the German insurer disputed the jurisdiction of the Polish courts. And the court's judgment is at page 926. And it's paragraph 33 first, which is the referring court asks, in essence, whether Article 13.2, read in conjunction with Article 11.1b, must be interpreted as meaning that it may be relied upon by a natural person whose professional activity consists inter alia in recovering claims for damages from insurers and who relies on a contract for the assignment of the claim concluded with the victim of a road accident to bring a civil liability action against the insurer of the person responsible for that accident, which has as its registered office in a member state other than the member state of the place of domicile of the injured party, before a court of the member state in which the injured party is domiciled. And if we could turn to page 927. There's a reference to the Kabeg, both the Sovag decision, the Kabeg decision, and the Vorarlberg decision, and the court picks it up at paragraph 39 and says those decisions are based on the reasoning that first, the purpose of the provisions listed in section 3 is to protect the weaker party by rules of jurisdiction more favourable to his interest than the general rules, and secondly, an assignee of the rights of the directly injured party, who may himself be considered to be a weaker party, should be able to benefit from the special rules on the jurisdiction of courts laid down in the combined provisions of Articles 11 and 13. That said, the derogations from the principle of jurisdiction of the defendant's domicile must be exceptional in nature and be interpreted strictly. And then moving to paragraph 42, it follows that no special protection is justified where the parties concerned are professionals in the insurance sector, neither of whom may be presumed to be in a weaker position than the other. Therefore, a person such as Mr. Hofso, who carries out a professional activity recovering insurance indemnity claims against insurance companies in his capacity as contractual assignee of such claims, should not benefit from the special protection constituted by the forum actoris. Although it's true that recital 18 of the regulation states that the purpose of section 3 is to protect the weaker party by rules of jurisdiction more favourable to his interest than the general rules, it's apparent that the action at issue in the main proceedings concerns relations between professionals and that it is not such as to affect the procedural situation of a party deemed to be weaker. In that regard, the fact that a professional such as Mr. Hofso carries out his business on a small scale cannot lead to the conclusion that he is deemed to be a weaker party than the insurer. A case-by-case assessment of the question whether such a professional may be considered as a weaker party in order to be covered by the definition of injured party within the meaning of Article 13 would give rise to the risk of legal uncertainty and would be contrary to the objective of that regulation, laid down in recital 15 thereof, according to which the rules of jurisdiction must be highly predictable. Such an interpretation is moreover supported by the objectives stated in recital 15, according to which the rules of jurisdiction must be highly predictable. And then it concludes at paragraph 47 by saying, in those circumstances, the answer to the question referred is that Article 13, read in conjunction with Article 11, must be interpreted as meaning that it may not be relied upon by a natural person whose professional activity consists inter alia in recovering claims for damages from insurers, and who relies on a contract for the assignment of a claim concluded with the victim of a road accident to bring a civil liability action against the insurer of the person responsible for that accident, which has its registered office in a member state other than the member state of the place of domicile of the injured party, before a court of the member state in which the injured party is domiciled. Now, so again, what the court in this case is doing is tying up the notion which has been identified, for example, in the reinsurance case, that the social protection is not required in cases of insurance professionals litigating between each other. But secondly, that where and adopting the Advocate General's position in CABEG, that where the person involved is settling or making and settling insurance claims as part of his professional activity, they are two classes which don't require social protection. And I've kept referring, my lady, my lords, to the fact that the reinsurance case establishes the exception and the deeming, and that means, of course, that the deeming mustn't be in irrebuttable presumption. And just to make that good, just for your reference, I won't read it all out, but it's the court's decision in UGIC at tab 32 of bundle PA2, the pages 1088 and 1089. And it's paragraph 64 to 73. I think my learned friend read out sizable extracts from that judgment, and I don't propose to repeat it. So with that in mind, now I appreciate that the court in Hofso was focusing on a particular instance of a assignee of rights of an injured party against an insurer. I appreciate that. But what I would say is, and putting aside the reinsurance case, which I've relied upon, what I would say is that if the rationale of the insurance section as a whole is to provide social protection to economically weaker parties, there is no reason why that position should be limited to Article 13.2. Secondly, there is no reason why it should be limited to an assignee after the loss as opposed to before the loss. And thirdly, and this is where I do rely upon the reinsurance decision in UGIC, is that the first class of persons not entitled to protection under Section 3 are insurance professionals in the context of a reinsurance claim which comes within one of the deemed parties referred to in Section 3. So it cannot be an irrebuttable presumption. So the principles which I draw from this is that the insurance section applies in insurance cases involving persons who are treated as economically weaker, but to decide who is an economically weaker party is not achieved by a case-by-case assessment. It's achieved by identifying classes of persons, and to put it another way, if you wish to identify a person who is not entitled to social protection, it's done by identifying a class. And the classes which have been identified by the court are professionals in the insurance sector and persons whose professional activity involves making claims against insurers under insurance policies.
What do you say would have been the position if Mr. Hofso had himself taken out a policy of insurance?
If that wasn't part of his professional activity, to protect himself against injury in the car, then of course he would fall within the insurance section. Because he wouldn't be taking out the policy for any professional reason. So the third question I will now address, subject to any questions the court may have, is does the bank fall within the relevant classes?
I mean, really, if I'm following this, the argument is that Article 13 deals with claims, with actions brought against insurance companies by injured parties, and it adds injured parties effectively to the list of people in 11.1b
Yes.
for that purpose. And there's been a lot of case law about what is meant by an injured party in relation to people including assignees and people with subrogated rights. And in that context, the court has focused on whether they are economically weaker parties and therefore within the rationale in recital 18. And so on the basis of that, you're wanting us, when we look at Article 14, which is to do with claims brought by insurance companies against the people listed in 11.1b, to read a similar sort of rationale into 11.1b as a way of limiting who counts as, for example, a beneficiary for that purpose. Is that the structure of the argument?
So, my lord, could you just repeat that last sentence?
That you then, in a sort of reversing the logic of the process, you then take the categories in 11.1b, and in deciding whether Article 14 applies to them, you use the same rationale we see in recital 18 as a means of restricting the scope of who falls within those expressions, particularly the expression a beneficiary.
Yeah, well, forgive me if I have misunderstood your question, but I'll answer it as best I can. And I don't mean any disrespect.
I'll try to make it absolutely clear. Yeah. You're using recital 18. You say the case law supports the use of rationale in recital 18 to understand who falls within the scope of the words the injured party in Article 13, and you say, applying the same rationale, we should equally limit the scope of who we understand to be beneficiaries within the meaning of Article 14, read with Article 11.
But I think you also preempted the GIE case, which is an Article 14 case.
UGIC. Sorry, GIE case.
GIE.
That's an Article 14 case.
Yes, it is an Article 14 case, and you say it uses a similar form of reasoning.
It does. One thing I would have to accept, though, my lord, is that GIE did say that the court in that case did say that, given the reference to policyholder, insured, or beneficiary in Article 14, it contemplates proceedings by the insurer against those parties. I think that's right.
The point I made was that the party, the defendant in GIE was not a policyholder, insured or beneficiary, but a co-insured. So there's no question of exception in Article 14. My learned friend invited me to explain, I think.
But I think I didn't say anything.
Said the same thing.
Yeah. So whilst, yes, nominally it's an Article 14 case, the court had dealt with it in a particular way. So, I'm sorry, my lord, I'm going to answer your question now. I'm not sure I've answered it. And again, if I misunderstood it, forgive me. The article, we begin with Article 13.2, because that seems to be the provision which is most often referred to in the authorities. There is no reason to distinguish an injured party as a deemed weaker party from a policyholder, insured, or beneficiary. So if the exception based on these particular classes applies to them, it applies to one of those persons, it must apply to others. And UGIC, of course, is an example where it applies to an insured. Again, if it applies to Article 13, there's no reason why it shouldn't apply to Article 14, because it's the rationale of the section as a whole which matters. So if the rationale does give rise to this exception, it must apply to all the relevant provisions in that section, not just some. So I hope that answers your question, my lord. I do want to deal with the final question I said I'd address, which is, does the bank fall within the relevant class? And I rely upon the Court of Appeals judgment, paragraphs 119 to 122, which is at CV2 7b, pages 310 to 311. Now, my learned friend relies upon the fact that the bank was not involved in making the claim to the insurers or settling the claim or negotiating the settlement agreement. But I would suggest that's an irrelevance. I mean, there was a claim under an insurance policy. It was a claim for recovery of sums paid under the settlement agreement. The settlement agreement wasn't a predetermined contract, and you can see one of the concerns raised by the court in relation to insurance policies as opposed to a settlement agreement, that the insured or policyholder would be presented with a predetermined, i.e. a pre-printed or standard form contract. And in this particular case, of course, the monies were paid, the insurance proceeds were paid to Willis in accordance with the letter of authority signed by the bank, but also in accordance with the settlement agreement. And the bulk of those funds were then paid to the bank. So at that very moment, if there was an economic imbalance between the insurers and the bank, it ceased, because the monies were all in the hands of the bank at this stage. However, I don't accept that there was an economic imbalance. What matters for this purpose is, and assuming I lose on issue 2, is this a matter relating to insurance? So assuming that's the case, the question we're concerned with, what are the objective attributes of the bank, and whether that lands them in a particular class, which is not entitled to the protection of Section 3. Now, the objective attributes of the bank are as follows, and these are all either obvious or subject to in evidence. The first is the bank was a financial institution which operated a marine insurance portfolio. That's agreed between the parties, and it's in evidence.
What do you mean by operated a marine insurance portfolio?
So one of the businesses that operated was the provision of marine finance on ships.
Yep.
That's not a marine insurance portfolio.
That's marine finance portfolio.
I may have misspoke. If I said marine
That's why I asked you.
I'm glad you asked. I didn't know I misspoke, and now I do.
Well, I wrote it down, so you did.
As did I.
I'm sure it's recorded in all sorts of ways. I didn't mean to say marine insurance, just so it's understood. I did not mean to say marine insurance.
No.
I meant marine finance portfolio. My learned friend, just for your note, paragraph 186.1, the bank asserts that Mr. Justice Tier found the bank is a small commercial bank. I don't believe that was found by Mr. Justice Tier, and I would ask you to look at paragraphs 1 and 2 of his judgment. Any event, the size of the concern is irrelevant, as was made clear by the decision of the court in Hofso. In this particular case, the bank advanced 40 million US dollars and 40 million euro to the owner of the vessel. So they're substantial amounts for a financial institution to advance. Therefore, it plainly had funds to make those substantial loans in respect of marine property. It took wide-ranging security for its loans, and we saw this yesterday by reference to the deeds of assignment. They included the assignment of insurance proceeds and also assignment of earnings. The mortgage which was taken out by the bank gave control of the insurance claim to the bank. Now, like the court hasn't seen this, it's probably worth looking at. And if I could ask you to look at Appendix Part 2, Tab 3, page 1994. This is a witness statement. You can see it 1988 of Mr. Christopher Zavos, who's my instructing solicitor. And this was a statement filed before Mr. Justice Tier at first instance. And you can see at paragraph 19 at 1994 a summary of the provisions contained in the mortgage. And these are also referred to by Mr. Justice Tier. But you can see that under the mortgage, the owner was obliged to provide the mortgagee with full information regarding any casualty or accidental damage. It provides in clause 5.10, the mortgagee shall be entitled to collect, sue for, recover, and give a good discharge for all claims in respect of the insurances. Clause 5.11, the proceeds of any claim under the insurances in respect of total loss shall be paid to the mortgagee. And finally, at clause 5.14, the owner shall not settle, compromise, or abandon any claim under or in connection with any of the insurances without the prior written consent of the mortgagee. So, therefore, the mortgagee had control of the insurance claim as far as the insurers were as far as the owners were concerned. The bank received the proceeds, as I've indicated, and the fact there was an assignment of insurances is a standard practice attaching to marine insurance, marine finance documentation, marine loan documents. And that was recognised by Lord Justice Gross, and I dare say it was recognised by Mr. Justice Tier. We have referred in our written case, paragraph number of our case, which refers to a textbook on the law of ship mortgages and also a law of marine insurance, which both identify and recognise that such assignments and loss payable clauses, as you find in this policy, are a standard feature of marine finance. Indeed, as far as the evidence the bank is concerned, and sorry, that's a reference. So 79, in our reply written case, it's paragraph 79. Subparagraph 8. Yes, 79. Yes, and it's page 267, which is the electronic page number in CV16C. That's where the references to those books are. And if I could also ask you to look at Appendix Part 2, Tab 2, page 1985. This is a witness statement, and I don't want to put too much emphasis on this, but it's reflective of the fact that this is standard practice. This is a witness statement of Mr. Yavuz Tafoun, who was an employee of the bank as a division director of the corporate credits department. And at page 1985, this is the only, he refers to the assignment, paragraph 25. And he states that the third defendant is the bank, of course had an assignment of the insurance and was lost pay as security for the sums due under the first and second loans. So the point there being, I appreciate it's not an in-depth part of your statement, but the words of course reflect the standard nature and standard practice of having these sorts of assignments as part of a marine mortgage. Thank you. So, for those reasons, we say the Court of Appeal got it absolutely right that this was, that the bank fell into a class which does not require the social protection of the insurance section. It's both a beneficiary in the sense of a lost pay, but we also say an assignee, and that falls squarely within the exceptions identified. And in those circumstances, whether as by reference to the phrase matters relating to insurance or by reference to the weaker party principle, the bank is not entitled to protection of Section 3. So, just to recap, issue 1 is the policy jurisdiction agreement. I've addressed the court on that. I'm not going to repeat anything. But if I'm wrong about that, then and we say we're right, of course. I don't want to assume it's not right. But if we're wrong about that, then we say the insurance section doesn't apply. Now, if that's right, then the court retains jurisdiction in relation to claims for damages for misrepresentation, which leaves over the claim for restitution. And that's where issue number 4 comes into play. And we say we'd invite the court to find in our favour on that particular issue if it became relevant. Now, and I would say, and coming back to Lord Reed's question yesterday, there is a real practical benefit for a determination of this appeal in favour of the insurers, because it does mean that the very substantial issues of fact which have to be determined against the owners in any event can be dealt with in the same jurisdiction as against the bank. And as far as the owners are concerned, we have no choice but to proceed with that claim in this jurisdiction. The alternative, of course, is there would have to be separate proceedings against the owners and the bank in different jurisdictions dealing with the same factual matters, which would be unfortunate. Now, the only other point I wanted to address the court on was the issue of preliminary reference. I've already mentioned that issue number 2, which is the issue about matters relating to insurance, is, albeit in a different factual context, is the subject of a preliminary reference to the European Court at the moment. Of course, as far as matters relating to insurance is concerned, we say both the Court of Appeal in the Commentary case, and indeed Bosworth, but also there was a recognition by the Advocate General in the flight right case, or right flight case, I can't remember, flight right, that there was to be an analogy drawn between the phrase matters relating to a contract and matters relating to insurance. And that, of course, is a matter which the court will have to consider. But as matters stand, the European Court hasn't dealt with the definition of the matters relating to insurance authoritatively. That then brings us to issue 3, which is the weaker party principle. Insofar as you probably say to yourself, he would say this, wouldn't he? But I will say it. That if we're right about this, then in terms of the weaker party principle, it's following established line of authority of the European Court. And therefore, it's one of those points which the court has considered on a number of occasions and has identified in different decisions who the classes of persons are. And therefore, the court, in this case, is particularly and well able to decide that dispute by reference to those decisions. If, however, I am wrong, then it seems to me that it may well be a matter which requires referral to the European Court. And then issue number 4, again, if I'm right, then there are the interpretation of Article 7, sub-Article 2, matters relating to tort, delict, and quasi-delict, we say have been the subject of interpretation in numerous decisions of the European Court from Calfellis onwards, and all we're doing is applying a literal interpretation of that adopted by those decisions. But if we're wrong, and therefore in those circumstances, if we're right, it doesn't require a referral. But if we're wrong, it may well do to clarify exactly what the court has meant on each of those occasions. So, my Lord asked about, is there a definition of beneficiary? And the answer is, as far as we can tell at the moment, there's none. It's none in the regulation and none we're aware of by the European Court. Now, unless I can help my lady and my lords further, they're my submissions.
I think not. Thank you very much, Mr. MacDonald-Eggers. Ms. Healy? Mr. Barry.
Thank you, my lady. A few points which I will make shortly. First, under the question of matter relating to insurance, my learned friend relied on the flight right and the committee cases, and the relevant pages to note there are for flight right. That's page 1738 and 1739, paragraphs 59 to 61. And I will make a compendious submission about those in a minute. And then in the commentary case, the relevant pages are 1336 and paragraph 52. And if, which we don't accept, they lay down any relevant test in contract, and if, which we also don't accept, that relevant test can be transported across to insurance, then the test is that the action must be based on an obligation which originates from the insurance. And in my submission, that is satisfied because this action and this matter is based on the obverse side of that coin, which is the non-existence of an obligation, i.e. the obligation to indemnify in the insurance. So on that test, the matter is satisfied and a matter relating to insurance here. And in that context, I do remind the court, if I may, about the point that I made about versluit, which is that the telling lies about an insurance claim is a breach of the insurance contract, alternatively a breach of the insurance obligation, and that is therefore satisfying the principle of, is it based on a breach of the relevant, in this case, insurance. Second point, my Lord Sales, in this context, asked my learned friend a question: what about the case of the employee who claimed restitution? Was that a matter relating to contract? And my learned friend's answer was, well, if it's an implied term, yes, but if it's a pure restitution, no. My Lord, the answer to that question is actually contained in the case of profit, which I relied on in contract. That's PA2 tab 29, pages 9595 at 1026. And the answer is, it is a matter relating to contract without any need for it to be an implied term as opposed to a restitutionary claim at law. The restitutionary claim in that case was under the relevant German I think statute, but I'm not sure. But it certainly wasn't a contract claim. So my learned friend's answer was in my submission inconsistent with the profit case, which he didn't deal with. The third point I would wish to deal with is the definition of beneficiary. And like my learned friend, we are not aware of an exhaustive definition of beneficiary. And we haven't inquired into the question because it's been common ground in this case that my client is a beneficiary. And therefore, it didn't arise. My submission is that we are definitely a beneficiary as loss payee. And even if we are also an assignee, that is incapable of taking away the benefit of being a beneficiary. So we don't get minus points for being something else as well. Once it's accepted, we are definitely a beneficiary. But insofar as it matters, my submission is this, that a beneficiary of an assignment before loss is a beneficiary of the insurance policy, because the insurance policy is from that time before loss for the benefit of the assignee, and that is different from a case after loss when there is subrogation or assignment, because what the subrogee or assignee is then the beneficiary of is a claim under the policy and not merely the insurance. And so if one is to define beneficiary, it includes loss payee and pre-loss assignee, but not post-loss subrogee or assignee who acquires not an insurance policy, but a claim. Now, the fourth point I would wish to make is my learned friend said, well, there is already an exception created by the reinsurance case, and therefore it's merely a question of how wide the exception is to Section 14. In my submission, the reinsurance cases do not establish any exception to Article 14. My learned friend said that a reinsurance contract is an insurance contract, and he is right as a matter of English domestic analysis, but in this context, the articles we're concerned with are ones that have to be given an autonomous European interpretation. And in my submission, the point of the reinsurance cases, including the Group Jossi one, is that a reinsured is not an insured, whatever English domestic analysis may be. And that comes from Schlosser It comes all the way through the decision in New Hampshire that it's not right to call a reinsured as a policyholder, which was the word then, and it is not an exception. It is that you're not within the definition in the first place. So the reinsurance cases do not establish an exception. You'll no doubt look again for that. My fifth point is Cabeg. My learned friend said that the court in Cabeg endorsed an exception or a limiting principle on the basis of reinsurance professionals and those regularly involved in reinsurance settlement. I would remind this court, that the court in Cabeg did not endorse those paragraphs of the Advocate General's opinion, that's 66 and 67. They endorsed the earlier paragraph, which was all about the definition of a weaker party being wide. It is only the Advocate General that is any support for any limitation based on those two exceptional cases. And I would also submit that what that is all about is the extension of the forum actoris rights to a subrogee. And this leads me neatly onto my Lord Reed's question to my learned friend, based on the wording of Articles 11, 13, and 14. Now, these are in the PA bundle and are at
799.
799.
Thank you very much. In my submission, my Lord Reed's formula should be slightly adjusted as follows, and that what the cases we've all been looking at are about are whether the rights in 11.1b, that is a right in a claimant to sue, that is a right of policyholder, insured or beneficiary to sue in his own domicile, and that's a derogation, extended to the injured party by 13.2. Injured party, Article 11 applies to the injured party. What the cases are all about is whether that right, that forum actoris in 11.1b, should be extended to somebody who is not a policyholder, insured, beneficiary, or an injured party. And so the question is the terms and the times at which there is that extension, and extension is the word that is almost invariably used in the cases, and the terms on which there may be an extension to a subrogee, because the case is all about subrogees in effect, or assignees of claims rather than policies. The terms on which the extension is granted is only if you are a weaker party or in a category deemed to be weaker. Now, my Lord Reed in my submission was right, and I think my friend accepted this, but if he didn't, he would have been right to say that his argument is that you should transport the terms on which there is an extension to somebody not named in 11.1a and b. I say transport. My actual submission is transform it into an exception in Article 14 in the mirror image situation. And we go right back to my earlier submissions, but why on earth would you do that in the various circumstances I identified, including that Article 14 reaffirms the basic rule of domicile of the defendant? And my learned friend rightly accepted, I think, when questioned by my Lord Hodge, that the only case in the whole bundle that's about Article 14 is the GIE and Zurich case. But the Zurich failed to take the benefit of Article 14 there because it was not a policyholder, insured or beneficiary. So they weren't even in Article 14. It was no question of an exception.
And that's your point, your fourth point about insurance law, yes?
That's right,
Yeah.
yes, yeah. And and finally, my Lord, the seventh point I wish to make is that my learned friend showed you provisions from the mortgage, and he submitted that showed control. my submission, no, it didn't. It showed that the insured, when negotiating a claim for its own behalf, had nevertheless to get the consent of the bank before settling. That's not control. That's a long stop requirement of consent and good discharge. And insofar as my learned friend's submissions at the end as to the bank are concerned, if there is such an extension as to be transported into Article 14, along the lines of the Advocate General in paragraph 67, then the question is whether my client is in the CABEG category of a large entity, but there's no exception, or in the category of a quasi-professional insurance company. Clearly not, unless I can help. I'm trespassing.
No, I think not. Thank you very much indeed. Thank you to everybody, to those who've been on their feet and to those who've done all the hard work in support of those who've been on their feet. And you know who I mean. And we will now go away and try and work out the answer to all four issues which you presented us with. Thank you. Court is now adjourned.